And the fourth and final case, another Ninth Circuit, I believe. Is that correct?
That's right. And this is a bit of a preview to the podcast because this one will be discussed when I drop the episode 31 of the podcast tomorrow and when it goes on Mondays. But this is the case Vega Aguiano v. Barr, published by the Ninth on November 24th, 2020. This is actually a reissue because it was published last November in 2019. But it appears that there was a bit of a fight amongst the Ninth Circuit judges. A fair amount of them wanted to go en banc on the issue, but they did not succeed. And so this is the final decision on the issue. And there are some concurrences and dissents, and the Ninth Circuit's fighting about it. But it's very complicated. I get more into it on the podcast, on the immigration review. But in essence, it's about reinstatement. And that's when an individual has a final order of removal that has been executed. And then that individual comes back to the United States, I guess in all occasions, unlawfully. Mm-hmm. And instead of starting new removal proceedings, ICE can just reinstate the final order of removal. And so long as they prove that the individual is who he or she is supposed to be and that they do have a final order, they can just remove that person pursuant to the final order. But in this case, the Ninth Circuit is reaffirming that if execution of a final order will result in a gross miscarriage of justice, it can't be executed. And you can challenge that in reinstatement proceedings. In the case of this individual, his conviction was vacated. And so he didn't have a conviction for immigration purposes, both at the time he was eventually removed and certainly at the time that they tried to reinstate it. And so trying to remove someone, even where there's a final order, where it will result in a gross miscarriage of justice, it can't be executed. Now, to me, it's a bit easier when, like this individual, the conviction has been vacated for immigration purposes. But it seems to me that what if, say, the categorical approach changes? The conviction isn't vacated, but the Supreme Court issues a decision, or they already have, such as the Discamps or Mathis decisions, such that the conviction is no longer a removable offense. What if you have California burglary, which is the very issue and the name escapes me, the Supreme Court's decision in 2016 finding that Section 16B of the finding that 18 USC 16B is unconstitutionally vague. So you can't have a crime of violence based on the probability of harm. It has to be the element. 16B is unconstitutional. What if you have a removal order based solely on 16B? It would appear to me that removal order is no longer valid under this Ninth Circuit decision. And so even with a valid removal order, that individual cannot be removed. Even with the valid removal order, even if you can't get the case reopened. And a motion to reopen based on that might actually fail because the board and the circuits have taken a pretty hard line that evolving immigration law will not necessarily constitute grounds for reopening. It's got to be a firm break. And the categorical approach is always evolving. Fair enough, a motion to reopen won't succeed. But the Ninth here is saying to me that in that case, the order can't be executed because they're no longer removable and it would result in a gross miscarriage of justice. So that I think that's pretty big.
Now, practically, if someone is here and ICE catches them and they're going to reinstate it, what do you do? Does the family call immigration lawyer? Immigration lawyer files a stay and then requests. Is that what happens? Or?
That's a good question. And this Ninth Circuit decision didn't actually discuss the procedure, but it seems to me that what you do is you can request a hearing before ICE. Mm-hmm. And in that hearing, I guess you'd get an attorney and you'd present legal argument to show that reinstatement is a gross miscarriage of justice. And if that fails, which it probably will, then you can immediately petition for review to the Ninth Circuit. It seems to me because the board has issued decisions that says it does not have jurisdiction over reinstatement. Yeah. So I think your only thing is to go directly from ICE to the Ninth Circuit or to any circuit court of appeals. That's reinstatement. But again, I'm talking about a situation where they've never even been removed. They've just been allowed, the non-citizen's been allowed to hang out for 10 years. And in that amount of time, they're no longer removable because there's been a change to the categorical approach or other area of law. I think that would be the same situation where when they tried to execute it, maybe you would go into district court in that situation, and from there go to the Circuit Court of Appeals. I wouldn't, that would be my guess, because there would be no proceedings in that case. I guess in that case, I would go to district court and try to do a motion to reopen at the same time.
Yeah. You know, there was another, I think it was Ninth Circuit about 6 months or a year ago. They said like the state of California goes back and changes the statute so that like a certain crime is 364 days instead of 365. You can't look back and fix the case that's already been hit by the old thing. So
that was a different. So I was going to talk about that case. That was actually in November as well.
But that was not recently. I felt like it was a year ago. Time flies.
No, that was on October 28th. It's Velasquez Rios et al. V. Barr. That's Cal Penal Code section 18.5. And I mean, so that's important to bring up, and that was the board's decision from 2018, which is maybe what you're thinking about. In 2018, matter of Velasquez Rios held that it's the actual date of conviction that matters, so they were upholding it in October.
Yeah.
But let me just look at this 1 second, because the interplay of these two decisions might actually be pretty important.